Well, if we have the United Nations Charter that tells us that parties to the UN Charter must not resolve their disputes through use of force, they must first resolve their disputes, at least seek to resolve their disputes through peaceful means. It means that somebody bothers you, the first thing you should think of is not, I'm going to bomb them or shoot them. It means, can we, if we find a state at the end of the conduct that is troubling us as a state, and we have a court of law that needs to tell us whether what's happening here is a question of rights and obligations in international law, should we resolve it by shooting and bombing because we have the weapons and means to do so? Or is it better for us to pose that question to a court of law, an international court of law? South Africa, in my view, regardless of how the substance of that question is answered, I think it was right that the question is posed as a question for the court of law. When people talk, when they talk, there's an opportunity for them to put their energy in that talk. Could be a talk in a court of law, litigating a case. That can remove the impulse to fight in the meantime. In the IC, the League of Nations, when the League of Nations was first created, there is a provision in it about states who have dispute try and resolve it by arbitration. At the time, you didn't have the ICJ or BCIJ. The requirement was to use arbitration to try and resolve dispute, and arbitration was supposed to be binding. And then they give it 3 months, okay, wait 3 months, cooling off period after the arbitration tribunals, that's when that is awards. Contemplated for a period of time. If you don't like it, and then we'll talk again. So that is an avenue of resolving dispute, letting tempers cool down, cooling off period. Courts can do that, litigation can do that. That's why I think it's a good thing for us to use the ICJ in the context of this obligation and governance process more than we have. And I think not only South Africa has given us that angle to it. Gambia did it in relation to Myanmar, and Canada and Netherlands did that in relation to Syria. The Syria committed torture. Ukraine did it in relation to Russia. That's understandable. Ukraine was at the receiving end of the conflict. But here, South Africa is doing the same thing. There's a value to that. So that is at the state level. I think beyond the state level, beyond that macro approach, it is possible as well to approach accountability in international law in a different way. At the micro level, at the level of human beings seeking remedy for violence they suffered in the context of war. What am I talking about? Not necessarily litigation at the ICC. We all know that the prosecutor of the ICC can start proceedings against the state. That's the state party to Rome Statutes, accused of violating the international law in violent ways. But the UN Security Council can refer cases to the ICC in relation to states that are not parties to the Rome Statute. If the Security Council doesn't veto it, that's not what I'm talking about. I'm not talking about criminal litigation now. I'm talking about yet another approach to resolving international disputes that we can explore that has not yet been explored. And that, I believe, the armed conflict we're now experiencing can give us an angle to. What is that? The right to peace. The right to peace is something we can think about. And peace, as we know, is something we all talk about. That you can hardly pick up a human document where peace is not mentioned once or twice. After 1945, after the Second World War, the international community decided now we're going to recognize rights and freedoms for individual human beings. They adopted quickly the Universal Declaration of Human Rights. In 1941, FDR had presaged that war was ongoing. FDR decided in his presentation to Congress that as when this war ends, international law will be developed in a way to recognize certain fundamental freedoms for human beings, the four freedoms: freedom of expression, freedom of worship, freedom from fear, and freedom from want. Those are like the cycle of what eventually got adopted as the Universal Declaration of Human Rights in 1948. And later on in 1966, the UDHR was amplified in a treaty form in two treaties that the international community had to adopt: the ICCPR, International Covenant on Civil and Political Rights, and the ECSR, International Covenant on Economic, Social, and Cultural Rights. If you look at the ICCPR side of the ledger, you think about a number of rights that we will recognize as civil and political rights. Think about any number as we go again, but think about freedom of expression, freedom of movement, freedom of worship, right to life, security of the person. That's on the ICCPR side. You look on the economic, social, and cultural rights ledger, you think of freedom, right to work. You think of social security, education, health, cultural life. Now, I want you to tell me all these rights, which one of them can you really meaningfully enjoy in circumstances of ruptured peace? Is there any one of these rights that you can really say, yes, I can enjoy this right when bombs are flying, guns are being shot? You can't. If you don't have peace, you really are not really going to enjoy any of these rights in a meaningful way. And in peace, then, is what we call the substrate norm, the substrata norm. Why do we take it for granted? Why don't we have it as an actionable human right in its own right? Right to peace, so that we can say, anyone who violates my right to peace, I should be entitled to remedy. There should be consequences for that. So that's what I mean by the right to peace as a fundamental human right that you can actually enforce in a court of law and can be consequences for. And you move again beyond the rights to peace, the value of peace. All the organizations of the international community, even the national community, is centered on the idea or the pursuit of peace. We want peaceful coexistence. We want citizens to enjoy the bounties of nature good in peaceful circumstances where everyone can actualize their full potentials. You cannot really do that meaningfully in circumstances where there is no peace. Relations at international level, I mentioned the Peace of Westphalia that gave international relations its early template, as it were, for international law, its early template. That resulted at gathering to pursue peace at the end of very lengthy wars. Peace of Westphalia. You move forward to 1899, we all had of the Hague Peace Conference in The Hague, 1899, the second one in 1907. Again, pursuit of peace. How can we organize international community so that we can all reap the rewards of peace? International community again being organized along those lines. 1919, 1920, Woodrow Wilson paroled his problems, and there is no one. The Archbishop of Canterbury once said, there is no such thing as a perfect human being. Every human being, look deeply enough, you will find their foibles, and you find their good values. So the Pastor Wilson, I give him a little credit for thinking about organizing the world along the lines of an organized international community. So we have to give that to him, the League of Nations, for the past time. Now we take the UN for granted, we can abuse it as it may please us. But what would life be for us without the UN really? It all started in 1919 with the League of Nations. Again, the idea of promoting and harnessing peace in a very profound way, 1919 peace. 1945, well, the League of Nations, well, how can we have the League of Nations when this rupturing war, Second World War occurred? We need to regroup, reform it, formed again, UN in 1945. First line in the charter, well, because they want to forming this organization in order to save future generations from the scourge of war, again, the pursuit of peace. So the formation of international organized community based on the idea of peace. Again, we say, if peace means that much to us, can we not do more with it? And that's why I argue that peace as a fundamental human right is not a form order. Perhaps all the wars that are going on now, especially the one happening in Ukraine, with one state waking up one morning deciding, look, we're just going to roll in there, invade the place, tells us that we have to do more with international law. And one way to do more with international law would be to harness the value of peace in ways that those who violate that norm can be held accountable. So the concept of rights to peace is something I think needs to be brought home in a very concrete way. In a matter of speaking, we can already say, well, the concept is there to an extent, although we don't realize it. How could it be there to an extent? Well, in international law, there's what we call lex lata and lex ferenda. What does that mean? Lex lata, the law as it is. Lex ferenda, the law as it ought to be. And looking beyond the law as it ought to be, I think we can actually move it on the side of law as it is. And the law as it is formed in a number of ways, international law, including customary international law. You can form it the clearest way to form international law, as we know, is to draft a treaty that starts out what we want to do, the consequences of the certain actions, and so on and so forth. So we have an international treaty. That is the clearest way. But that's not the only way we form international law. International law can be formed by customary international law, being what states do repeatedly, hopefully, with intent or motivated by the mindset that they're doing that thing because they're compelled by law to do it, because they either want to follow the law as they understand it, or they want to lay down the law to follow in future. So law regarding conduct. And one way you have that law regarding conduct is when the UN General Assembly adopt resolutions on the same concept repeatedly. If they do it often enough, you can start distilling principles of international law from that. Because law regarding it's called formation of international law, government international law, practice of states accepted as law. Usually you think about, well, states in wherever they are, be it in Washington, through Washington or South Africa, Abuja, Nigeria, and so on and so forth. What they do over there will tell us what they think about international law, whether they're forming customary international law. But that can be inefficient because you have to be, following each state, what are they doing precisely in certain regard to distill international law from that. States may be thinking different things or may have other things bothering them, so they're not speaking in the same, marching in tandem on the same issue. So it may be difficult to distill international law from what states do, from their own disparate conduct from where they are. The best way, in my view, to gauge that is when they're all gathered in one room, as we are gathered here now. They're gathered in one room at the UN General Assembly in New York, and they adopt resolutions speaking to the same proposition from the same mindset. When you distill that repeatedly, you can see your customary international law there. And in that regard, we do have customary international law on the right to peace. Because between 1984 and 2016, we have that repeated resolutions of the UN General Assembly or the UN Human Rights Council in Geneva adopting declarations on the right to peace, telling everyone people have the right to peace repeatedly. So that can give us arguably international customary law on the right to peace. But that's not enough for what I'm hoping we can do with the right to peace. Yet we can say, yeah, right to peace exists in that way. But I do think that it will be better for us to have it in a treaty, in a clear form. If we have a treaty on that treaty will do a number of things, at least 5 things. It will put beyond question the idea that peace exists as a fundamental human right. We have it. It will also spell out the consequences of violation of that right to peace. We spell it out. It will specify the grievances that we have in mind when we say our right to peace has been violated. Now, on that, let's keep in mind that the idea of right to peace is not entirely new. It has been tried, as I said, during all these UN declarations. There's usually debate about that. And that debate comes because people try to pack in too much on the concept of the right to peace. suddenly it begins to worry a lot of folks. So people are scared, well, we can't make it to everything for everyone, right? Right to peace, you say, well, but Mali will tell you in the song, well, wherever there's inequality, there is war. War everywhere. So we have what's that? In any circumstance in which one group sees themselves as superior to the other, there is war. So Mobali will give you the concept of the right, something that disturbs some people about the right to peace. Well, if you're going to say right to peace because of racial discrimination, people say, discrimination, well, in our country, we have that problem. So we're not quite prepared yet to sign on to this thing. That's what we're talking about. And then gender equality. Again, there should be gender justice, equality of men and women. But if you don't have that, people say there is a troublesome concept of peace as well. Religious discrimination, all manner of discrimination, sexual orientation, so on and so forth. So again, these are important values that must be fought where they belong. We have CERD, Convention on all forms of racial elimination, all forms of racial discrimination, and CEDAW, and all that. So these are important instruments that we should fight to amplify the values of these instruments. But without talking about the right to peace, it is possible to make it simpler, to reduce it at the level of, we're talking here about the use of armed force in certain circumstances, invasion of a country because you lack their resources or because you do not recognize their right to exist, so you create other places. So that gives the idea of right to peace a certain specificity that doesn't add everything to it and make people go, are we sure we want to do this? So that's one thing we basically specify what we mean by right to peace. What this sort of violation of that, what would violation of that right look like? So we do that. That's an instrument. Again, we also will specify in a treaty the question of immunity. It's not something that comes up all the time. Would a head of state enjoy immunity when they commit certain violation? The treaty will spell out, as has been the case in other treaties. No, there is no immunity for those rights to peace. So that would be in the treaty, specifying that way. We will also have in that treaty one vital amenity that will make it work. What is that? Because it will be an international treaty, it means that the court of every state that is a party to that treaty would have the jurisdiction to enforce it. So you do need an international court to enforce it. It will be the national courts now that will enforce the right to peace, in the sense that, assuming the US ratified this treaty, some of you are lawyers here, somebody decide, well, my country was invaded, my life has been ruined wherever it is, we can no longer live there, we're now refugees in the US, we're going to sue whoever invaded our country. And the judge here renders that judgment on the basis of this treaty. That treaty, that judgment can be taken and enforced in any other country that's a party to that treaty without fresh litigation. Basically, reciprocal enforcement of judgments. Actual judgments, one thing that can be done. Now, when you do this in this way, you use national courts to enforce international law in this way, enforce a right to peace. Suddenly, those who make wars, aggression, or commit terrorism or other crimes will start thinking twice about it. Because it's no longer just there and the prosecutor or the ICC for prosecution. Suddenly you're looking at an instance where they have to account to indefinite number of jurisdictions for violation of international law in the environment where that is the second way in which I think that we should be looking at the paradox of opportunities presented by all these wars we see all over the place and ask ourselves, can we do more to strengthen international law? Can we use this opportunity to strengthen international law in ways that will make it hopefully more difficult for us to keep on seeing these candidates received around the world? Those are the thoughts I thought I'd share with you today. And I'll leave it at that and take any questions from you. Thank you very, very much.
Thank you for that wonderfully thoughtful lecture, Judge. And as you can see, the judge in a previous life was a litigator, and I'm sure it was obvious. And the floor is open. We can keep the queue. I will keep the queue and make sure I thank you. Please raise your hand. I have Teresa first, you in the front, and then the gentleman in the back. So we might collect questions later since there are so many. Would that be okay with you?
So I love your idea about a right to peace. I think it's an amazing idea. I just kept thinking about the US, for example, that has this tendency of signing treaties but not ratifying them and making litigators have a big headache on how to enforce human rights treaties. No, so how, as a follow-up to the question I did in the last class, how can we hold accountable these countries that maybe don't ratify their international obligations or don't even recognize that they have international obligations?
We have front.
We're kind of going in line with that, which I also discussed with you after last class. Craig Wilkenberg, the Human Rights Commissioner in the office in New York, recently resigned because of the atrocities in Gaza that he was on the ground investigating. And he said that like he witnessed a lot of human rights violations, which I'm sure you read his letter, and if you didn't, you should. I just was wondering what you thought about that and how we should proceed, given that someone who was investigating these human rights violations for years has called it out in courts, gotten to this point.
And last question, just around the gentleman at the back.
Your proposal seems very focused on, well, first of all, thank you for giving this speech. The proposal seems very focused on interstate conflict. What do you think the role international law can play in interstate conflicts, in particular for non-state actors in areas where state power doesn't reach? A good example, one that I'm thinking of right now, is in the Democratic Republic of Congo, in the east, where there's just very little state reach in there. Do you think your solution can address that issue? And if not, what do you think the options are to address that?
Thank you. In all of the questions were asked of the ensuring that states ratify treaties that they actually sign, it is really a matter of the domestic system and the citizens encouraging ratifications to happen. I mentioned the Convention Against Genocide earlier in my talk. Adopted in 1948, but also it was ratified in the US. 40 years later in 1988. 40 years later. And that was due to the efforts of Senator Proxman anyone heard of the name Senator Proxman? If you Google, see a hand up there, thank you. The Proxman Act is the domestic legislation, the US President ratified the treaty and made it part of US domestic law. It's named after him, the Proxman Act, because forget how many thousand, no less than 3,000 speeches or so he made on the floor of the US Senate urging ratification of the statute, because he decided from about 1968 to 1988, but it was adopted. He said he would not rest until he saw that instrument ratified. But in 1968, was already 20 years adopted of the statute. He started every day, from that day, every day, he would make a speech in the US, on the floor of the US Senate, urging ratification. Eventually, he won in 1988 when the ratification occurred. So it is for states to, citizens to mobilize their MPs to ensure that members of parliament or congressmen and senators, as it were, to ensure that treaties that they care about are ratified. So that's one way to go about it. The question about, can you please repeat?
Yeah, I was just wondering how you felt about it, given your work in the Human Rights Commission in our office, and like his resignation and his investigations in the human rights and that have dated before this in general, given everything happening, and like why there hasn't been, I guess, action taken, and just like an addressment of his letter.
The Frank Cargo was the UN, I think he was the head of the UN High Commission, or Office of High Commission of Human Rights in New York, who resigned over the war in Gaza, specifically because he said that the UN, the system had failed the people of Gaza effectively. That is his view. I don't think that is too much of a controversial proposition. We have in the ICJ now debates about should the people of Palestine have their own state, and what are we seeing as a result of failure to do that? Is that what's resulting in this? Personally, I do think that there should be a two-state solution myself. I do think that how we tease that out in terms of the questions of international law that should attempt how that question is resolved is something that we need to handle with care and thought and delicacy. It is something we know has been divisive in North America in particular and around the world for good reason. There's a reason why it is that. It is easy for somebody to give a certain definitive answer to it. And at some point that can be done. But right now we have the question before the ICJ on South Africa's case, as well as an ongoing, in the last 2 weeks or so, proceedings at the ICJ dealing with that. I do think time has come to resolve that conflict in a very definitive way, so that the people of Israel and people of Palestine would enjoy the rights to live in peace. So that is, I think I can leave it at that for now. It is long overdue for that reality to occur. Right now, the funding question about violations of interstate actors can commit. My right to peace proposition does not leave out non-state actors, rather, from committing violations. As I indicated earlier, when we have a treaty that treaty will define in precise terms what we mean by right grievances. What are the grievances that would provoke that concern in specific ways? One way would be interstate conduct, like a war of aggression would be that. Terrorism can also be agreements. War crimes can be agreements. Non-state actors can commit those. The aggression is where you have state-to-state conduct, but terrorism and war crimes can be committed by non-state actors, and even if defined in that way in a treaty, it will make non-state actors also accountable for that kind of conduct. And as I said, with the example I gave earlier, a court in Massachusetts here can adjudicate that question about what somebody had done in the DRC on the basis of that treaty we were talking about. And yes, non-state actors can be held accountable.
Time for maybe one or two more questions. Eve.
So you touched on this earlier in my class, but while you were president of the ICC, Donald Trump was president of the United States. And he took a very, shall we say, uncharitable view of your work. And it is quite possible, you're no longer on the ICC, but it's quite possible that Donald Trump might become president again. Can you give us a sense of how you think your colleagues might respond to what would seem to be a continuation of his previous attitude towards the ICC, were he to become president? And how would that affect the course of justice going forward?
Thank you very much, Professor Ogisami. You had to have that difficult question, wouldn't you? Well, on a very serious note, one would hope, of course, it's a speculation. No, you can say, well, there is such a thing as intelligent speculation, you were saying. We will hope that the US American system, in all the various ways that it can do that, is able to restrain their head of state from doing certain things. That's the starting point. And the US doesn't have a perfect system of government, but I do think that for the most part, given the challenges it can face, it does handle it better than other countries that have the same challenges. Other countries that have the same challenges. If you were in another place, what the thing that was viewed widely as a coup would have come to fruition in other places. And now the story will be different. So I was thinking from that genius as well would come other ways of trying to restrain the American leadership from doing things that do not represent what America stands for. Now, I'm told that with the prospects of the Republican primary unfolding as it is, other countries and the broader international system beyond the US have already started preparing themselves for the eventuality of Mr. Trump coming back, assuming that happens. I think at that stage, my colleagues in the ICC, I would not presume to say what they will do, but I like to think that they would figure out how to deal with it. If I was able to deal with it, I'm sure others can deal with it in their own time. I think I can leave it at that for now.
One last question, please.
Are you able to discuss some of the major ethical dilemmas and challenges you faced while at your time at the ICC and how you went about navigating those?
There are always ethical challenges in life. Always. One of the difficult one, for instance, would be you are in diplomacy and there is a limit bound. See diplomats, you may find that not only me, but other judges to attend events. And the question or question mark could always be, well, how would you be shaking hands at reception, for instance, or carrying on conversations with diplomats whose states might have issues pending before the ICC, for instance? And I reprised that in a manner of saying that there was actually a time when that kind of concern was an issue for judges in national jurisdictions, when judges were expected to lead one-star lives. You're not supposed to mingle with members of the bar and so on and so forth. But my view of that kind of thing is that judges are not delicate livings. It doesn't mean that because you come in contact with somebody, it means forever your objectivity has been compromised. A different question if there's more to it than that. But it didn't come to it. But usually what we encounter, the question we encounter more often, while you're constantly being invited because that's your job to, attend diplomatic functions. And so these people come from states that have issues for the ICC. I just sometimes that kind of interaction can help you explain to people how the system works, but it doesn't compromise the system profoundly. So that's the adequate challenge that I can really think of. With all these.
So unfortunately, we're out of time, but inspired by your call for an actionable right to peace, I want to end by talking about utopias. So long, long ago, in a land far, far away, that is the present-day country of India, there was a powerful king named Ashoka, who was famous for his brilliant and ruthless military conquests. Until his bloody campaign, 8-year-long campaign, against the kingdom of Kalinga, a war that he won, but at the cost, as Ashoka's edicts tell us, of 150,000 persons carried away captive, 100,000 slain, and many times that number dead. No longer able to tolerate carnage and destruction, Ashoka renounced war and converted to Buddhism, devoting himself to peace for the rest of his reign. Like so many histories, this too has elements of both some truth and some myth-making. But what it's holds out is the promise of hope in humanity, our ability to change, and to make our utopias possible. So thank you so much for reminding us of this capacity in ourselves and for your commitment to helping us translate it into reality. Thank you, and thank you.